Good afternoon, ladies and gentlemen. My name is Sandy, and I'm the Senior Legal Counsel at the Hearings and Mediation Department at the Intellectual Property Office of Singapore. I'm very honored and privileged today to be here to share with you about our experiences and initiatives in relation to IP mediation in Singapore. This is a very brief overview of my presentation. I will briefly explain why we at IPOS believe that mediation is highly suitable for IP disputes. And then I will share about our IPOS offerings, our partners, before ending with some success cases. To understand why we believe that mediation is highly suitable for IP disputes, we first look at the peculiar characteristics of IP disputes before looking at the characteristics of mediation. You can see some of the bullet points on the slide. Some peculiarities of IP disputes make them highly suitable for mediation. One clear example is the fact that IP is territorial in nature. So if one pursues litigation, one will have to navigate through each and every country with the respective different laws, procedures, and languages, and with no guarantee of a similar outcome, even if the facts at issue are identical. On the other hand, opting for mediation enables one to specify the outcomes at one single setting, saving a lot of time, cost, and effort. This also points to the efficiency of mediation as a dispute resolution option for IP disputes. And I will share some of the success stories later, as I mentioned. Another point, another peculiarity of IP disputes is that IP can be highly technical in nature and therefore it may need technical expertise. So patents, for example, are generally highly technical in nature. Next is confidentiality. Many or most of the IP disputes are highly confidential in nature. There are certainly benefits of being able to obviate the need to publicize technical know-how or just even generally business sales and promotional figures. Last but not the least, it is important to preserve relationships, not least because many of the different technological developments requires collaboration between several parties. Now, before I move on, let me just emphasize at this point that intellectual property is not just about enforcement. There may be circumstances where you need to enforce your legal right. But what we are saying is for most cases, it is possible to coexist. And coexistence is ultimately about reaching a win-win solution which works for both parties, preservation of business relationships between both parties. And this, we believe, can be achieved through mediation. We will now turn to the characteristics of mediation as the arrow points to the mediation on the spectrum of dispute resolution options. Before I begin, it is important to have an overview of the dispute resolution landscape before dwelling proper and diving into mediation. Litigation is the default dispute resolution option or the conventional dispute resolution option, which everybody is very familiar with. Other options are therefore called alternative dispute resolution options, and mediation is one of the popular alternative dispute resolution options. In other words, there are many ways to resolve an IP dispute. It is important to understand the different ways to resolve an IP dispute, as each dispute resolution option has its own advantages and disadvantages, which explains why each dispute resolution option sits at a specific location at the dispute resolution spectrum, as you can see in the slide. Now we turn back into the characteristics of mediation. As you can see there in the slide, it is closest to mediation. That is because it is highly informal in nature. However, unlike negotiation, parties can choose and appoint a specific third party, and this third party can be an expertise or a specialist in IP. Third parties involved in mediation can only assist parties to come to a resolution of the dispute. They cannot determine the solution for parties, unlike in litigation where the judge hands down the decision. And therefore, parties are in full control as to how they want to resolve the dispute. In particular, parties are free to take into account of any business interest for the resolution of dispute. They are not confined to the legal remedies that are available under the law. And of course, mediation is highly confidential in nature. There is no need, unlike in litigation or even at a tribunal hearing before IPOS, to publicize sales and promotional expenses at the mediation session. Mediation also saves time and costs. Due to the territorial nature of intellectual property, as I mentioned earlier, mediation can resolve disputes on a global basis, all at once, at one setting. And as I mentioned, I have concrete examples later. And certainly, last but not least, mediation preserves relationships because it is generally amicable and it is not adversarial like litigation, where it is all about win-lose. Mediation is all about win-win, which obviously is very important in business. Now, before I move on, I just want to conclude in relation to a recent development which enhances the option of mediation for IP disputes, and that is the coming into force of the Singapore Convention on Mediation as recent as September last year. The convention basically works in a similar way to the New York Convention for Arbitration, and in essence, it actually promotes and eases the enforcement of cross-border mediation settlement agreements. I hope by now you have been able to catch the many overlaps between the peculiarities of intellectual property disputes and the characteristics of mediation. Now, the quote in the slide is made by Chief Justice back in 2016. It is a bit dated, but I believe that it is still relevant today and it's worth reading it in full. An ideal system of justice is one that delivers justice that is customized to each type of case, keeping in mind the subject matter, the parties, and the desired outcomes. In this regard, it would perhaps be timely to embrace a paradigm shift and understand ADR not as alternative dispute resolution, but as a reference to appropriate dispute resolution instead. The point is that we should understand ADR not as an alternative dispute resolution option, which is thought to be secondary or inferior to conventional dispute resolution or litigation. However, on the other hand, we are not advocating that ADR or alternative dispute resolution is superior to litigation. But what we are emphasizing is that we need to use the most suitable dispute resolution option to resolve the IP dispute at hand. All the available dispute resolution options are simply tools for us to choose from. And as I mentioned, in some circumstances, litigation may be suitable. For example, if you want a precedent so as to warn other potential infringers that you will take them to court if they infringe your IP. But what we are saying is that mediation is suitable for the majority of IP disputes. And as I mentioned again and again, but hopefully you will understand why later, we have successful case examples which we will share later. Before I delve into the IPOS offerings in relation to mediation, I just want to set the context by giving you a very brief snapshot of the administrative and judicial resolution of IP rights disputes in Singapore. Now you can see IPOS is here. Disputes before IPOS are appealable to the High Court, where the IP court resides, and then it can be further appealed to the Court of Appeal. As to the kind of disputes that falls within the jurisdiction of IPOS or the courts, it is very much dependent on the law. And here I have in the next few slides a snapshot of the various forums for the different types of IP disputes. So as you can see at the top, for pre-grant opposition action for trademarks, it falls solely within the jurisdiction of IPOS. Whereas for post-grant revocation actions for trademarks, you can start an action whether at IPOS or in the courts. Now I will share with you about our IPOS offerings in relation to mediation. To begin with, mediation has been integrated into our contentious dispute resolution process. The flow chart on the slide shows the progress of a typical IP dispute or the most common IP dispute before IPOS, and that is pre-grant trademark opposition process. Right after the close of the pleadings at the case management conference, parties are encouraged to consider mediation. As the name suggests, it is a stage of the proceedings where we try to manage the cases. Parties are encouraged to consider mediation at this early stage because at this point, parties have not spent any money to prepare the evidence. So if they proceed to mediate at this point, they will save a lot of money and time. However, on the other hand, we also recognize at times it may be easier to make a decision once parties are able to assess the relative strength and weaknesses of their case as well as that of their competitors. Therefore, we also broach mediation again at the pre-hearing review stage. As the name suggests, it is the stage just before a full hearing. At this stage, parties would have had sight of each other's evidence and would have had a better sense of the strength of their respective case to decide whether or not mediation is a viable option. In fact, even if the hearing date has been set, parties are free to opt for mediation as long as the case has not been heard. So you can see, we weave mediation at the various stages of the contentious proceedings before IPOS to encourage consideration of the same. To put our conviction as to the suitability of mediation for IP disputes, we actually offer funding for parties to attend mediation of their disputes before IPOS. As at today, the amount can be Sing dollars, $12,000 per case, or 6,000 Sing dollars per party where there are foreign IP rights involved, or Sing dollars 10,000 per case, that is Sing dollars 5,000 per party where there are only local IP rights involved. The point is to encourage parties to try out mediation and experience it for themselves, its effectiveness, and the scheme is intended to encourage a mindset change. Before I share about our success cases, I want to go into our partners without which the implementation of the funding scheme would not have been a success. First and foremost, we have the WIPO AMC or the WIPO Arbitration and Mediation Center. WIPO Arbitration and Mediation Center Singapore office is the only office outside Geneva. It has been in Singapore since 2010 or 2010. It has over 2,000 neutrals from all around the world, including specialist mediators and experts who are knowledgeable in relation to IP. And just to point out that during this COVID season, WIPO AMC actually provides complimentary online docket and video conferencing facilities. Next is the Singapore International Mediation Center. The SIMC has a panel which comprises of experienced mediators from all around the world, as well as different technical experts from different industries. One point to note is that SIMC offers a up, meet up protocol with SIAC. SIAC stands for Singapore International Arbitration Center. And the benefit of this is that mediation settlement agreements may be made into consent awards. And this may be useful if parties to the dispute have yet ratified the Singapore Convention on Mediation. Also, as recent as October last year, SIMC is in collaboration with WIPO to handle IP and tech disputes. Similarly, during this COVID season, SIMC offers discounted fixed fee arrangement and online mediation services. Last but certainly not least is the Singapore Mediation Center. The panel on Singapore Mediation Center includes senior and principal mediators who are specialists in the area of intellectual property. The SMC operates various industry schemes, including IPOS' own funding scheme. Now, I will share with you our success cases. We have several since we launched the EMPS funding scheme. And this is the very first one because it is very memorable to us. Both parties were foreign parties, one from the US and the other from Thailand. Parties managed to not only resolve the dispute before IPOS, but also achieved global resolution covering in total 6 jurisdictions, 1 US and the other 5 ASEAN countries, namely Singapore, Thailand, Vietnam, Malaysia, and Indonesia. This was achieved in about just merely 20 hours, less than a full day. The cost amounted in total to Sing dollars about $11,400, which is split between 2 parties, and this quantum is totally subsidized under our funding scheme. In fact, there was some left over from the funding scheme to partially defray mediation-related lawyer fees and disbursements. Compare this to the scenario where parties have to wade through the different litigation systems of the different countries. Imagine the time and cost involved in having to appoint counsel or lawyers to understand the different languages and laws of each jurisdiction. Can you fully appreciate the time and cost savings here? And yes, we have very good feedback from the party. The Thai party said that he is very glad that there was a win-win outcome. The US party said that the success of the mediation was very significant, as apart from settling the existing dispute, it protected their brand image and business development in the region. The other success story that I want to share is under another one of our funding scheme, mainly the mediation promotion scheme. One party is a major food and beverage business in Singapore, while the other is a relatively well-known UK entertainment outfit. Parties were ensnared by disputes across different jurisdictions. Again, not only did mediation resolve the dispute before IPOS, but it also achieved global resolution. And what I want to point out is that mediation was completed in 1 day via video conferencing. Specifically, the UK party saved a lot of time and cost by not having to fly to Singapore to attend the mediation. And the total administrative and mediation cost amounted to about Sing dollars 3,500, which is split between 2 parties. And again, this quantum is fully subsidized under our funding scheme. And again, we received very positive feedback from the parties. The parties shared that they were very happy with mediation and that they will still use mediation again, even if funding is not available. The last case that I want to share is actually literally the very first case which came into IPOS when we launched the mediation scheme. A Singaporean construction company filed oppositions against 3 trademark applications owned by 3 commercially related entities based in Singapore, Malaysia, and Indonesia. All the outstanding disputes were resolved again on a global basis, and all it took is 1 day of mediation. The matter was finally settled within 4 months after the commencement of the mediation. And this is quite remarkable because parties had been in dispute for 20 years. Notably, the mediator was able to bring the parties closer by using Bahasa Indonesia with the Indonesian party during the private caucus to build trust. So there goes one of the advantages of mediation, that parties can choose. Unlike in litigation where you cannot choose the judge, in this case, parties can choose a mediator who is not only technically savvy or well-versed in the relevant IP field, but also familiar with the relevant languages and cultures. We have collated a few successful cases, and if you are interested, you can take a look at the compendium of successful cases, which is available at the link in the slide. And here are just 3 selected cases. And if I may just conclude for completeness sake, even if there's no settlement reached, mediation is not wasted time, nor is it wasted money, because there are actual cases where parties manage to narrow down the number of issues which are before them and decided to finally withdraw the case from IPOS. So when you attempt mediation, nothing is wasted. So these are some of Singapore's experiences and initiatives in seeking to encourage IP mediation. We hope you have found the session interesting and useful. We'll be happy to hear from your experience and learn from you as well. Thank you very much for your attention.